Madam, I'm Genevieve Ling from Genevieve & Co. Today, based on question 5, our group will discuss the topic of cost for damages for breach of contract and no order as to cost for illegal contracts. But first, we must understand what costs are. Costs are the fees incurred for the use of a court and are seen in civil and criminal courts of all levels. The provision governing costs in civil procedure falls under Order 59 Rules of Court 2012. Under Rule 1 of the provision, the interpretation as to the costs, determined costs, fixed costs, and costs must have been laid out in the statute. Additionally, the provision interprets contentious and non-contentious business in reference to the legal provision at 1976. Order 59 Rule 1 states that both contentious and non-contentious business have the same meaning under the legal provision Act.
Next, we will look at the general rule on orders as to costs. Firstly, reference must be made to Order 59 Rule 2, subsection 2 of the Rules of Court 2012. The rule states that the costs of and incidental to proceedings in the court shall be in the discretion of the court. As such, the court shall have full power to determine by whom and to what extent the costs are to be paid. This was affirmed in the case of Donald Campbell & Co. Ltd. against Pollock. In this case, the court, in its discretion and reference to the district court, ordered the applicants to pay the respondent costs of the application for leave to appeal. The discretion, however, is to be exercised in accordance with settled principles. Stated in the case of Menteri Hal Ehwal Dalam Negeri against Karpal Singh, the question of costs to be awarded in any particular case depends on the discretion of the judge. The discretion is a judicial discretion and must be exercised according to settled principles. There must be sufficient materials for the judge to exercise his discretion so that the discretion will not appear to be exercised. Next, Order 59 Rule 3, subsection 2 of the ROC 2012 states the golden rule for costs upon when costs follow the event, which is granted at the court's discretion. The usual or general rule which the court will follow in awarding costs is costs shall follow the event. In this situation, the losing party pays the winning party's costs, and the losing party will bear his own cost. The general rule sometimes gives way in particular circumstances. For example, the court may award the winner only a portion of his costs, or his costs from or up to a specific stage of the proceeding. Sometimes the court may make no order as to costs, in which case each party will be left to bear his own. And sometimes the winner may have to pay the loser's cost of certain matters.
My name is Nasrin and I will be presenting on the basis of assessments of costs. According to Order 59, Rule 7, Subsection 1 of the ROC 2012, costs may be dealt at any stage of proceedings and costs ordered shall be paid at the conclusion of proceedings unless the court otherwise orders. However, how exactly does the court calculate the cost? Is there any guidelines to be considered? So the answers can be seen in Order 59, Rule 16, Subsection 1, where the court may consider relevant circumstances in assessing costs such as the complexity of item, the skill, the specialized knowledge and responsibility, the number and importance of documents, the place where business is transacted, the importance of cost to clients, and more. Another guidelines can also be found in Order 59, Rule 8, where courts will consider special matters in exercising this discretion, such as any offer of contribution or order of settlement under 22B, the conduct of all parties before and during proceedings, the attempt to resolve by any means of dispute resolution, and also the extent of parties to adhere to relevant pre-action protocol or practice direction.
Costs normally sought in breach of contract case are costs on standard basis, provided under Order 59, Rule 16, Paragraph 2 of the Rules of Court. For this, the court will allow a reasonable amount in respect of all costs incurred. These exclude legal fees paid to the lawyer. Meanwhile, court also has discretion to order costs on indemnity basis in exceptional cases, referred to Order 59, Rule 16, Paragraph 3 and Paragraph 4 of the Rules of Court. These include legal fee. It's claimable against the losing party except if those amounts are unreasonable or unreasonably incurred. Example of costs on indemnity basis so in breach of contract cases are as follows. Firstly, in Yabuhua case on fraudulent misrepresentations. Secondly, in plastic mega construction Senjam Berhad case on the unreasonable refusal to discontinue an actions notwithstanding a concession met. And thirdly, in the Star Papyrus Senjam Berhad case, which include the various unmeritorious defenses. In these cases, the cost on indemnity basis can be sought. More often, the order to cost does not amount to granting the legal fee in full. In Lipico's case premised on fraud, the legal fee is granted via special damage, but not ordered as to cost, so it can be granted in full. It is merely because the faulty party has the burden to redress all wrong and max reparations.
Good day, Doctor. My name is Jenny. We have learned about the possible costs that may be ordered by the court in cases of breach of contract. Now, the question is, will the situation remain the same if it involves an illegal contract? Generally, it's understandable that if the defendant successfully establishes the defense of illegality and thus win the case, the defendant is entitled to claim costs from the plaintiff. But looking from another perspective, if the defense of illegality refers to the illegal contract entered between the parties and the defendant later seeks to be protected under this defense, even though the defendant knowingly to be a party to the illegal contract, this would be improper to have the cost be made against other party because both of them have offended against the law. So in order to restore justice and equity, the court will make no order as to cost to the party, meaning to say, both of the parties have to bear their own costs irrespective of whether they are the winning party or not. So to illustrate this principle, we can refer to Cheng Mun-sia against Tan Nam Soo. This is a case involving a sale and purchase of land in Singapore to a foreigner. The foreigner later claimed for a refund of deposit. In this case, the whole transaction was illegal because Section 3 of the Singapore Residential Property Act prohibits Singapore land to be sold to a foreigner. With that, since both of them were parties to the illegal transaction, no order as to cost was made to the parties. Now I'll pass the floor to my groupmate. Thank you.
To conclude, Order 59 of the Rules of Court is significant as the court is granted with the discretion to award gross sum as cost rather than having the cost taxes. Not only that, the court also may deal with the cost at any stage of the proceeding by virtue of Rule 7, subsection 1 under the same provision. In order to do so, the parties must qualify under the law as stated by Ms. Nasrin in her presentation, and nevertheless, there are some exception for the general rule where the court will determine before granting the cost. First, the court will look at the exception to cost itself, and second, the court will take another look at the exception that can lead to no order to cost. For example, the court will determine whether the contract is lawful or illegal because it will affect the court in granting the cost. So I think that is all from Genevieve and Co, where law is for everyone and we share because we care. Thank you and have a nice day ahead.